Thank you very much for your introduction, Durgesh. Yes, I'm independent. I'm on nobody's paycheck. In reality, when I talk about data protection, I am talking about my own ideas. Of course, I work with several clients. So I've tried to get my head around the changes, upcoming changes. The blurb for this event indicated that we may have this bill already enforceable by spring 2023. Of course, that hasn't happened. We're now talking of potentially mid 2024. But even so, opinions are divided as to whether or not we will have this bill in this parliament. Essentially, we have completed one of the two stages, the common stages. Some law firms, Hogan Lovells, authoritatively claim that we have a good chance of making it into law before the next general election, and therefore, no surprises, organization should start preparing for it. Other experts, R.D. Kola is an independent data protection expert, just like myself. It's quite clear that it will struggle to become law in this current parliament. And the fact that it was mentioned in the King's speech just 7 days ago doesn't guarantee we'll have it as is. So to give you a bit of history, this was introduced in March. It has been subject to a carryover, which means that it will continue into the next parliamentary year. But the likelihood of it staying as is, in my opinion, it's above 50%, but not by much. So my takeaway, it's be aware, let's absolutely prepare, but let's not tear up the GDPR compliance program that we have in place. So this is a little bit of sort of warning. What we're discussing may still be subject to change. But on the basis of what we have now, we have a couple of first impressions, but I thought were quite damning. One, in terms of seeing this digital information bill as enabling data collection without many safeguards for individuals. No surprises there for the Open Rights Group. And a second one from another independent data protection expert, which it's actually damning in the opposite direction, because it tells us it's actually a damp squid. It does a little bit of tinkering at the edges, but really it doesn't change that much. Now, the King's speech a week ago announced it, among other things, as a bill to encourage innovation and machine learning. Now, that's coming from the King. You have to take that quite seriously. So what is the sort of King's version of the bill? What are we promised? From the King's speech, we're promised reduced burden on businesses, especially small and medium enterprises, removal of barriers on scientific research, boost of economy, that's a big claim, and enabling innovation. So a more proportionate and practical way of going about it than the EU GDPR. Scientific research use of personal data gets clarified, and this is absolutely true. We'll deep dive on that. This is interesting. It's digital verification services. I will not go over this in detail tonight, but if you are in electronic ID validation, this is an important bill for that sector. Smart data schemes, again, about sharing data to enable sort of saving schemes. It's an interesting concept, but again, I won't be deep diving on this. Better use of data in health and adult social care, law enforcement, and other government services. Absolutely, this bill really does it, and we'll go into that. It does change how the Information Commissioner Office operates, and it hopes to maintain international data standards that are high enough so that the UK retains adequacy with the European Union, so that data can continue to flow between the two. So it promises a lot, and it does do a couple of things very well. So let's move on very quickly. So this is the headline grabbing novelty. Let me see if you, okay. These are kind of 12 points that you may have found in different summaries of what has been around so far. So personal data gets redefined. I won't spend a lot of time, but if you remember, the UK GDPR along the EU GDPR defines direct identifiers and then indirect identifiers. You have data that has the potential to identify somebody when combined, when used in conjunction with other data. And that's that has been a sore point, because the use in conjunction of other data in the original GDPR referred to any other personal data held in any system, not necessarily your own business or your own IT systems. So if out there in the wild, there are data sets that could complement your own data sets and identify individuals, then the data you have, even if on its own would not be sufficient to identify an individual, knowing that there are other data sets out there that you could use in conjunction with it makes your personal data, makes your data personal data. So for example, you might have data in your systems that don't identify individuals, but you combine it with the electoral roll, for example, or you combine it with other data sets, and there you go. It's very easy in 2 steps to re-identify individuals. So this bill restricts or sort of puts some limitations on what other data sets you have to be aware of that could turn data that you have in your systems into personal data. Essentially, it's only data that the receiver has already. So it's not an open-ended anything that combined with the data and could lead to identification makes your data personal data. So that is a very interesting definition. If it stays, it may have may give you peace of mind, but it is pretty much a philosophical point. I don't think many organizations that I have worked in would necessarily have paid too much attention to re-identifiability of data sets held in the organizations by virtue of combining it with other data. But anyway, this is an interesting definition. It makes a big stand on this. It redefines automated decision-making pretty much essentially as solely automated decision-making. So it's defined as automated if there is no human involvement at all. Legitimate interest can be used as a condition of processing without having to do that balancing test that pits the individual's interests against the organization, the controller's legitimate interest, that you have to carry out, and you have to store, you have to document that you have carried out before using legitimate interest at any point. So that is removed. If the purpose of your processing is on a list, there's a list of recognized legitimate interest. If your purpose is on that list, then no need for balancing test. And this is an interesting one. The next one is research. Research is defined very broadly, and it's a very interesting redefinition. We'll spend time on that. You will not need to serve a privacy notice if the data is acquired from the data subject, even when you repurpose it for research, and that's interesting. I'll come back to that. And you can use it for developing certain AI systems. And there's a kind of 2 or 3 steps you won't find any mention of machine learning, generative AI. You won't find large language models mentioned in the bill, but there are 2 or 3 steps, and it removes 2 or 3 obligations, which pretty much mean that you can reutilize data to train models. And this is absolutely true. If it stays as is, this is a guaranteed result of the bill. So that, I thought we would want to spend some time on that. Expands data sharing capabilities. The dreaded DPIAs, the data protection impact assessments, are now only carried out with high-risk processing, which in fairness is the same as it's now, but they're called something else. So that's a little bit of tinkering with names more than substance. The next one is actually quite evident. The threshold at which organization can refuse a data subject access to their data, essentially the point at which you can say, no, your requests are excessive and disproportionate, is much lower. So it is easier, it will be easier to push back on data subject access requests. The record of processing activities, the ROPA register, currently required for organizations that have over 250 employees or smaller organizations which have high-risk processing. If the bill stays the same, it will only be required for organizations that have high-risk processing, even large ones that have over 250. If they have no high-risk processing at all, ROPA will not be required. Cookies get a few exemptions. There's a lot of focus on nuisance calls, and fines have increased from 500,000 to 17.5 million, or 4% of global turnover. So robocalls, marketing text, SMS will be in the crossfire for the new sort of bill. This made headlines. Data protection officers would no longer be mandatory and will be replaced with senior responsible individuals, only for public bodies and high-risk processing organizations. And this is interesting. To attract business from abroad, the need to appoint a UK representative for controllers and processors established outside of the UK is removed. So I think the hope there is that we will attract more business. Okay, let's zoom in on a few definitions which will make a difference if they stay as they are. The definition of research and technological development are the key ones to look out for in enabling machine learning and generally speaking, sort of artificial intelligence innovation. So any time the regulation refers to processing for scientific research or scientific research purposes, we mean, says the bill, processing for any research that can be reasonably described as scientific, publicly or privately funded, no matter what, and whether carried out as a commercial or non-commercial activity. So any research that can be reasonably described as scientific. So I see no bars, I see no real obstacle to extending this definition to absolutely anything, even military research. I see no reasons why it shouldn't be expanded to include military research. So let's move on to the next interesting definition, and that's technological development. So while research has been redefined, technological development is introduced but not defined. So let me show you what this means. Such references to processing for scientific research include processing for the purposes of technological development or demonstration or fundamental research or applied research, as far as these can be reasonably described as scientific. So technological development, proof of any kind, demonstration, fundamental research, applied research, as long as you can reasonably apply the adjective scientific to them, are scientific research. There's a very big impact, so bear with me, hold on with me. If we're talking, however, about public health, then research is in public health is scientific research only if the study is conducted in the public interest. So essentially, we are excluding big pharma pretty much from scientific research, or big private medical scientific. So there's a green lighting here of personal data repurposing, and we'll see why, for a range of activities that are very, very broadly classified as scientific research. And this vagueness, when we refer to any form of technological development, really strongly, very strongly suggests that lawmakers intended to include machine learning, large language model, generative AI, anything that will come out in the future. So there's only the limitation of public interest for public health. And let's look at the second leg of this sort of maneuver, the new requirements for considering a purpose compatible with the original purpose. Remember, in order to repurpose data, you had to assess whether the purpose was compatible, and if it's not compatible, in order to reuse data that you obtained previously for different reasons, you have to go back to the data subject. Article 13 used to say that if you got this data from the data subject, before you use it for a new reason, a new purpose, you have to go back to the data subject. You have to tell them what you're doing. You have to advise them and tell them about the new purpose. So there is an obligation currently on the controller to notify the data subject if there is any further processing for a purpose that's different from the one it was collected. And you have to tell them what this other purpose it's going to be. Depending on the basis on which you collect it, then the data subject may withdraw consent if it was consent, may object to processing if it was a different lawful basis. Depends on what lawful basis you obtained it first. When you used to obtain the data not directly from the data subject, but from other sources, public sources or directories, or you simply obtain this data commercially, there was an allowance that allowed you to say that if it was impossible, it would involve disproportionate effort, or it would defeat the purpose for which the repurposing was happening, you were let off the hook. You did not have to go back to each data subject to tell them that you were going to repurpose their data. But that was particularly only in the case of data that you got from sources that were not directly the individuals. But what this bill says, it gives the sort of the option that arguing that providing information is impossible to notify the data subject about, or involves a disproportionate effort, whether you obtained it from the data subject or you obtained it from other sources, you're let off the hook. You can go ahead, you can repurpose personal data for research, public interest archiving, or statistical purposes without first notifying the data subject. So let's pause, because the two together are quite powerful. Firstly, you don't need to let the data subject know that you're going to repurpose your data for research. And that's a big help. It removes a big obligation, it removes a big headache if you are into obtaining as much data as possible. And the second, if you go back to the previous slide, the definition of research is very, very broad. So that means that pretty much anytime you can lay your hands on a data source, whichever purpose it was originally collected from, if you can argue that it is for research, that it is for scientific research, and if you can argue that it's going to be impossible or disproportionate, difficult to notify everybody, you can just go ahead and utilize it for whatever research or technological development you want. And so you see how getting hold of data, getting hold of very large quantities of data sets for training your models becomes a whole lot easier in virtue of these two redefinitions. Durgesh, stop me if I'm boring you or if I'm not making sense.
No, absolutely.
Okay, so
You're on track.
we're following these two moves, yeah? So
Yep.
two definitions. One, broad and vague interpretation of technological development, catch-all, very catch-all definition. Scientific, anything that can reasonably be said to be scientific is research. And then you don't need to tell the individuals what you're doing with the data. There you go. So green lighting, I think, is a very diplomatic way of saying it. And there is a sense in which data access rights, the organization had a point. This is a bill designed to make the data economy turn along faster. Okay, let's new requirements. This is also a very interesting third leg of the data for scientific research purposes. What happens to consent? What happens if the basis on which data was originally collected was consent? You have no way of recontacting those individuals because you're given the green light. You're kind of uneasy because consent, you say, well, it could be withdrawn. Is it lawful? They didn't know what I was going to do. Consent always needed to be for a specific purpose. Remember, consent was really very tightly defined. You need to know exactly what you're consenting, what data you're consenting, what the use, what the purpose, what the lawful basis is, what the retention period is. So consent was full of sort of guarantees around it, full of limitations. But now there's a definition of consent that is very, very specific for scientific research purposes. We could call it a subcategory of consent, that is the scientific research consent. So we have a scientific research specific definition of consent. Now, this is one of the sort of paragraphs which took me longest to unpick, and I think it could still be improved. And if anybody in in Parliament is listening, please improve it, because it really makes very, very hard reading. So it could be greatly improved for clarity. But I understand at the moment, a data subject consent for data collected for a different purpose a long time ago is considered valid consent for scientific research in any case in which, at the time it was sought, it wasn't possible to identify all of the purposes for which data was to be processed. So it was a consent for, let's call it, opaque purposes or incomplete purposes. Let's accept that is a situation which you might face. You're seeking consent for that specific area of research is consistent with general ethical standards relevant to that area of research. And you're giving the data subject the opportunity to consent only in part to part of the research, not the research in total. If you manage to make all these three happen, then I understand it that as long as you offer it the opportunity to consent only to part of research, and you follow recognized ethical standards, even if at the time the consent that was given did not list all the purposes, you can repurpose it. You can repurpose it and you can consider the consent valid. So that all consent is sort of grandfathered, if you want. But it is a very, very specific scientific research consent. So these three redefinitions are what I think correctly allow the king to say that this will facilitate machine learning. So that is absolutely correct. If it stays as is, that is how it's going to happen. There are other interesting ways in which data is going to move more freely in society, and these are to do less with scientific research and more to do with public sector. So let's move on to the schedules. The schedules are appendices, so to speak. There's two in particular that make it really, really interesting for me, especially if you're working in the public sector. If we were in the room, I would ask for a show of hand to know how many people in the room are in the public sector versus the private sector, but I can't. So let's say you're 50-50 split. So I hope to grab the attention of that half of the room that isn't into machine learning, but is into government departments trying to understand, can I share? Should I share? What's going to happen next? So if you are processing for these list of purposes, democratic engagement, safeguarding vulnerable individuals, crime, emergencies, national security, public security and defense, or, and I'll come to that, disclosure for processing described in Article 6.1e, then you can certainly go for legitimate interest as a lawful basis, and you don't have to do the balancing test, as I mentioned earlier. So this is one of those cases in which you have an automatic recognition that a lawful basis apply. You don't have to do the balancing test. You can go ahead. You have a lawful basis. Now, the interesting thing, if you're into government departments, you may often have found that government departments need data to discharge their function, to discharge the public task that they're set up to do, or they are exercising official authority. So government departments often talk to each other and say, well, I need this data to discharge my duties and carry out my public task. And the other department says, well, fair enough. That's your public task. That's not my public task. So why should I give you my data, says one department to the department? Well, fair enough. I'm happy it helps you discharge your public task, but it doesn't give me a lawful basis for giving the data to you, unless there are specific gateways or memorandum of understandings between departments. I don't know if you've ever had to witness one of these exchanges, but they're fascinating exchanges. So currently it is true, departments don't necessarily find it easy to get at the data of other public sector sort of departments. If, however, this bill passes, the fact itself that I'm asking you, Durgesh, for your data, and I'm indicating in the reason why I want this data, that it will help me discharge my public task, you have an automatic legitimate interest basis. So even if giving me this data doesn't really help you at all discharge your public task, but doesn't even help you in any of your interests, the fact that I'm declaring that it will help me discharge my public task gives you a legitimate interest. So this is one of those things in which really, if it goes ahead, you'll start seeing ministries, social services, anybody share data a lot more. There's a lot on safeguarding vulnerable individuals. At present, it's actually very, very hard to get data out of social services, and rightly so. It is a very sensitive area, and data gets gets inaccurate very quickly. You know, data captured 1 month is no longer accurate 2 months down the line. So sharing data in these circumstances where little differences make a big impact is a difficult thing. But the fact that you have a legitimate interest basis already means that you really don't have to soul search and say, do I have a legal basis for it? You automatically have. It's a no questions asked if you want. Okay, so a powerful enabler of data transfer across public sector departments. There's another interesting thing, and this is also connected to public sector and private sector. Right, so this is compatibility of purpose, Schedule 2. Again, data was collected for one purpose a long time ago. When can you say that using that data again is compatible? When can you repurpose that data and say, oh yes, it's a compatible purpose? Again, it looks like a very similar list. If your purpose is one of these listed purposes, you can say that whatever the original purpose of the data, your new processing, your new repurposing, it's going to be fine. And can I draw your attention to the bottom, second from the bottom, taxation, just to drive the point home? Absolutely any personal data sources collected for whatever purpose by any organization, private sector, public sector, can be lawfully repurposed for taxation. You have an automatic compatibility of purpose. Then, of course, you need a lawful basis, you need a retention period, you need everything else, but the purpose, it's automatically recognized. You don't have to worry, can I use that to drive tax evasion out of a country? Yes, you can. The answer is yes, you can. So this is a very, very substantial schedule. And in my reading, essentially it greenlights data transfer in vast quantities from the private sector to the public sector. This is a provision that allows the public sector to go knocking on every organization it can find and say, I need it for legal obligations, taxation, or vital interests of data subjects, emergency crime. You have a compatibility, a ready-made compatibility of purpose. So I think these are the aspects which I found personally more fascinating. Beyond the headline grabbing, no more DPOs, no more ROPA, records of processing activities. I think if you are into machine learning, or if you are a vexed sort of civil servant, this bill really has been written with you in mind. And I think with that, I'd like to close and take questions.
Oh, thank you so much, Hera. That was really interesting and eye-opening. So I've got a couple of comments in the chat which I can take through. And if you have any questions, please raise your hand rather than everybody talking at the same time. That would be easier to manage. Simon says he thinks data rather than personal data reuse for research in the future, it may have impact on NHS data in the future. And to me, it's not just NHS data, it's more for the use of, as you said, public sector.
It's public health.
It has opened doors to accessibility, if you like, to the public sector.
Well, let's kick this around. Let's say you wanted data for the next vaccine. What did we say? We said that as long as you can reasonably call the research scientific, tick, you can. Vaccine research is certainly scientific. You could repurpose data, and you could be commercial or non-commercial. You could be publicly or privately funded. However, if you are in the space of public health, your research, scientific research, only for studies conducted in the public's interest. And I think that cuts to the core of using health data for private gain, and calling that reuse scientific. I mean, trying to get hold of that data on the basis that you want to use it for scientific research, that there's a higher bar there. The research will be deemed scientific research if you're conducting that study in the public interest. So I don't think that you can that this bill will enable an NHS data grab. I would rule that out. I will rule that out.
And Tom further goes on asking, is this implicitly an expansion of investigatory powers? It allows more data sharing for the sort of national security reasons that you might want those powers for?
I think that's a yes.
Yes.
I think that's a yes.
Yeah.
I must admit, I haven't read, but I haven't read the provisions in great detail, but a first look at them told me that crime, emergency, public security are all defined very, very broadly, which is a sign that you really want to go for it. Yes. Normally.
It's given sort of the free hand for the government agencies and those specific security reasons, which is understandable. But when it comes to specific individuals, or as you said, vulnerable individuals, how do you then start protecting those data sets? And especially in the newer technological generations with AI, Gen AI, all that, because once the data is out there in this complex digitally connected world, how do you then start protecting those data sets?
It's a very good open question. I think it's a rhetorical question. You already know the answer. You can't. Once they're out and somebody claims to be doing scientific research, firstly, you're not notified. So you don't know where your data has ended up. Nobody has an obligation to tell you that they're using your data. And secondly, even if you were to find out and you gave it for consent at the time, they're going to use that old consent as valid for research. So you can't. Yeah, but I suppose if you find out where your data is, you can say, "Oh, I remember I gave you this data on the basis of consent, so I'm going to withdraw my consent." But by gum, do I know where my data is? I absolutely have no idea. I have no idea how I gave my data, who has it, and whether it was consent or not. So yeah, I think we all know the answer to that.
And Chair has a comment saying dilution of privacy and expansion of investigatory powers. I agree. But then also that then it leads to the further question, as we said about data flow. We had the provision of data processors, controllers, restricting it within the realm of UK or Europe. How do we then control when it's out in this connected world, which goes outside of, say, for example, European Union, to geographies which has little or no data protection laws in place?
Is your question asking me what happens if data from EU countries come to the UK and then goes out of the UK into... Okay. I can tell you that everybody's very worried. I can tell you that everybody in Europe is reading this bill very carefully. There is a genuine fear that the UK could become a data laundering sort of paradise. So yes, I mean, there's absolutely no two ways about it. The Brussels and the European Commission will be reading this line by line, and we'll be looking at how it's interpreted by the courts, by the ICO. But yeah, I think you hit the nail on the head. This is one of those aspects that could jeopardize adequacy.
Just on that note, then, sorry, Shahid had another question. How would this impact traceability when data subject request access to the data?
Well, if this data passes, I think you're going to, as an individual, you're going to get a lot more pushback. You're going to have a lot more answers that say disproportionate effort or vexatious request, even though, of course, they may not be. There may be genuine first-time attempts by you to get the data, or they could charge you. So we might start seeing fees being asked for accessing your data. I think that's very, very likely. I mean, I know very few organizations that are happy to respond to data subject access requests within 30 days and make a complete and perfect job out of it. I've met very few organizations that are good at that, but yeah.
Chiara, John here. What's the definition of a high-risk organization, please?
Very good point. Very good point. A high risk is defined by example, and there's a non-exhaustive list. But essentially, if any processing, any way of using this data goes to encroach and touch those fundamental rights and freedoms that you have, I don't know, freedom of movement or freedom or family life. I mean, whenever you have a potential effect on a fundamental right, then you have a high risk processing. So you're very correct. It is one of those thresholds that are hard to define. What is high risk, what isn't? And the best that both pieces of legislation, the old GDPR and this one do, is give a non-exhaustive list. Yeah. but very good question. Very good question. Are you dealing with high risk, John? Have you got borderline examples in mind?
No, I was thinking, of course, of dear old Nigel Farage and being debanked by NatWest. Is banking a high risk organisation?
Yes, access to, yes, I think it would be, yes, it would count as an organization which whose processing is high risk. It can absolutely, it can prevent you from accessing your assets. It can have an impact on how your assets are treated. Yeah, absolutely, yes. That would be a high risk organization.
Would high risk also involve the volume of personal data being processed? Would that be a criteria as well?
It is one of the things you have to have regard to when you look at high risk. Absolutely, the data and the quality they're all, if you're processing Article 9 sensitive data, political leanings or sexual orientation, of course, you're into high risk processing territory. Yes, absolutely.
Simon has a comment saying scientific research could include population health profiling, which he recalls was one of the big reasons for health data sets to be attractive to provide paid for services.
This is a good question, because there was one exception for demographic data, and I didn't focus on it. So I don't want to give the wrong answer to Simon, but if you look at the definitions, you will see that the bill definitely has a section on demographic data. But yes, pass. I really have to pass on that. I did not focus on that. What does Simon do for a living? Why this interest, can I ask?
Simon, if you want to come off mute.
Let's make this a two-way conversation. Come on. Oh, well, Simon is shy.
Hello. No, I don't know if you can hear me.
Yes.
Yep, you can.
No, it's just a passing interest. I've done various roles, including getting to know GDPR a lot better and all the sort of rules and regulations around data. But I'm actually in cybersecurity and just that area. But I've taken a particular interest in the management of our own NHS data from originally opting out, and obviously the requirement, the NHS digital provider, as well as American companies vying for that data and holding it to account, basically, and obviously aware of the American firm, I think Palantir, which are interesting company, as well as trying to second guess where we're going. But that's my interest.
No, I think, yes, I have that Palantir sort of use case very, very much front of mind. And I think this bill does actually protect from that, if it stays as is. But, it's a very complex bit, and you don't really know how it's going to shake out until it's all done. But yes, I think there's a sensitivity around it, which means there will be close scrutiny of those provisions. Certainly at the Lords, I would expect that to be very, very high priority, very, very high attention and scrutiny to that aspect. But yeah, thank you for flagging. It's absolutely.
No, thank you for
hot area.
I hope it is scrutinised more, but yes, there's some hope.
Sorry?
Yeah, it's good to hear that regarding extra scrutiny, and of course a lot of things fall back to the House of Lords, which a sensible unelected house, but we end up relying and getting some good results from the House of Lords often, and hopefully they will keep up the sort of our end of it of wishing to not have anything particularly watered down in an unreasonable and exploitable way, shall we say. But thank you for your answer.
No, I have high hopes as well for the second leg of the journey. That's absolutely, we're on the same page with that. Yes.
Andrew has another question asking, are these changes bad for individuals and weakening their rights over their own data?
I don't think there's any point being diplomatic. The answer is yes, they are weakening rights. But that assumes a lot, however. It assumes that organizations are actually capable of applying the UK GDPR and the EU GDPR as it is meant to be applied. And if you work in this field, you know that that is very often far from the case. I mean, there's so much that is not perfectible, but not yet perfect in the current implementation of the GDPR, that in many ways you could also say this bill sanctions what's already been happening. You know, I haven't met many organizations that go out and reach out to the individual, say, hey, we're going to repurpose your data. The new purpose has nothing to do with the original purpose, so we're telling you, you can exercise your right. I don't know about you, but I haven't met many. and I'm a particularly strict sort of data protection person. So if it got onto my desk, I would have said, no, you're not going to do that. But it never even gets to my desk. So stuff happens. And in many ways, I suppose individuals' rights are already very much in peril because it's just very hard.
It is, yeah.
It's impractical. So it's almost a bill to legalize current mainstream practice, which now we frown upon and say, oh, sharp practice, but in fact it's happening. So let's be real.
Yeah. Just following on from what Simon said about the House of Lords, Tom has an interesting question asking, how likely is it, do you think, that the Lords will considerably modify the bill as is? If so, which areas you think?
Very good question. I think the likelihood is very high. But I don't know. I generally don't know which areas are going to be the most contentious. And in many ways, this is still a very much an open match. I don't think the Lords have preconceived ideas of what is business friendly, what is not business friendly. So I think they are, I don't want to say learning on the job, but like everybody else, we're trying to get our heads around generative AI. We're trying to get our heads around, you know, the general artificial intelligence. And so how much can we mold this bill to put guardrails around this this development without blocking it, without preventing its further development? It's high on everybody's agenda. It's front of mind for everybody. So what I think will happen is that they will scrutinize it and they will improve it. But it's also possible that it will come to a recognition that this bill cannot do the job of policing AI, of offering guardrail for artificial intelligence. We're certainly trying to offer guardrails for the data economy of how data flows, but yes, it's possible we're going to have to be a bit hands-off and say, okay, we need another piece of legislation for AI. But certainly there's a sense in which we can't throttle this development by making data access more difficult. There's a sense in which we need to access data. We need to work with it better, and then put guardrails around it. But there's a sense in which I don't know how general this sense is, but certainly I think in the UK the policy wins are such that the model of individual consent and even individual control over one's data is seen as unrealistic, as no longer fit for purpose. So the shift is now placing obligations on controllers or on organizations for sort of guardrails, not on individual exercising control. So yes, it's a very good question, and I wish I had a more precise and concise answer. I realize that I don't know what to expect. I really don't know what to expect. But what I do know is that if the BCS or any other member organization is keen on influencing the debate, there's still room for that. There's still a lot of potential to feed, into the policy debate with expert opinion.
I think, interestingly, it coincides with one of the data protection summits happening in the next few days and weeks with the IAPP out in Europe. That would be interesting to see what happens there as well. Simon has a very good comment. It would be interesting to see if Max Schrems shows an interest in this. Absolutely, not just him, there would be many more. And one from me, if you like, and I'm possibly talking in for many of the DPOs out there. I know you mentioned DPO role won't be mandatory. It would be falling in for senior individual within the
Senior
business,
risk,
which is the right thing to do. But how and what do you think would be that impact on the data protection officer role? I know it's currently with only high risk or public bodies, but that might change over time.
I fear that there's going to be a knee-jerk reaction. I'm already starting to see it. Organizations are going to say, "Yippee, we can get rid of a DPO," and they'll rush to cut costs on headcount, and because you can give the senior responsible individual role to somebody who has another role already in the organization, so the conflict of interest is not such a big concern any longer. You're going to see a lot of IT folks given the senior responsible individual role on top of the CISO role or on top of the chief, I don't know, chief security officer, chief information officer. I think we're going to see a lot of muddles, a lot of unemployed DPOs, and a lot of mess, because it is a complex area, and you don't need a single person. You need a whole team to do it properly. But yeah,
because when GDPR came in place, DPO was one of the most important rules, and now we are moving away from that. So
absolutely, 100%. Yeah. Very good questions, Yogesh. Very good questions.
Thank you so much. I think it has surged very interesting questions.
Yes, please connect on LinkedIn.
Absolutely.
I think I know some of you, but not all of you. And absolutely, yes. I can respond on LinkedIn to very specific questions, or I can learn from you, because I suppose we've all done certainly part of the data protection job, whether in IT or whether in the DPO office. But yeah, it's a learning curve, and no, the bill doesn't mention machine learning and doesn't mention artificial intelligence, but it's definitely designed for it. Let's put it that way.
It's always been open to interpretation. How do you take those individual terminologies, if you like?
Yes. And a good indicator is how vague it's been in introducing technological developments. When you see legal fudge, you say, "Oh, I know what's happening here." I know where we're going with this.
Oh, thank you so much. I don't see any further questions, but if you have, you still got time. Otherwise, everybody has been thanking you for the interesting and stirring presentation. So
thank you
My
so
pleasure.
Much. Thank you for inviting me.
Our
and
pleasure.
I hope you had a good AGM, and I wish you every success in the new year.
Thank you.
Okay. Bye-bye then.
Thank you all.
Bye-bye.
Bye, Chiara.
Bye, John. Thank you for inviting.
Thank you.